Present arms. Pledge of Allegiance, National Anthem. Detail. Order, arms. Rifle team. Right shoulder, arms.
That's 20.
Face. Mark. Left.
What if he's picking up the hobby?
Forward.
Yeah, so right now it's streaming. Nicole, you want to sing? Do you sing? Do you sing or no? Check 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Jacob, hopefully you can hear me. Test 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Check 1, 2, 1, 2.
Face. Port arms. Present arms. Pledge allegiance, national anthem. Detail. Order, arms. Rifle team. Right shoulder, arms. Right face. Mark. Arms. Forward, arms.
I'll go wait.
Keep looking out there.
He's panicking. Oh, yes. Jacob, test 1, 2.
Oh, okay, there it is. Wow, that's you just walked on.
Let's try it. I see it's.
Okay, so one of the well, wow, that's just yeah, that's not.
No, it wants to be out on that. That's not good.
Yeah, yeah.
Are you streaming? Are you? Well, it's not you handle it, but. Two connections.
Solid. I haven't seen any starters.
Yeah, it's like a little more. It's like just a hair.
I can't,
Yeah, yeah. As it sells back in, it's like oh,
I can't even come out, right? Because they're gonna close the door or something.
well. So yeah, but for the break, don't come out. I guess what's.
Yeah, so this is all an add-on, honestly. This isn't here normally. Yeah, here's the list. And then obviously added on files, but this is,
when you see it. Mic test. Check 1, 2, 3, 4, 5.
Okay.
Good morning. How are you? Good. How are you? Good. You all set? You all done?
Everything looks good.
How are you? Friday. And then we'll.
My feeling is if you think you have something you can contribute, you should go. He doesn't know what's going on. Well, he thinks. Did that work? But he said he's going to. He said the bench. I think this was so I'm working on it.
She was here last night.
Morning. Regardless of your professional relationship, this is what you understand. Most of the time. Somebody's a very empathetic person. Next time there's a date, you better apply.
Mic check. 1, 2, 3, 4. Crystal clear. I'm gonna do one more. Check 1, 2, 3, 4, 5, 6.
There's a whole host of problems. He's in charge of
switches, and I'm just not in his stable. I don't. Turn it down.
Duck 1, 2.
Oh, did you want me to talk into any of these mics? Or you're good?
I think we're
That's what I'm saying. Gerard, got a nice turnout. Got a nice turnout.
1, 2.
Check 1, 2.
1, 2. A little louder, a little louder. Good morning. Good morning and welcome. I'm Judge Norman St. George, and I am privileged to serve as the Deputy Chief Administrative Judge for all courts outside of New York City. And if you are not from upstate, you say, where is that? And so we're talking about Buffalo in the west, all the way to Albany in the east, all the way to the Canadian border in the north, and down to the end of Long Island, Suffolk County, Montauk. Those are where all the courts outside of New York City are, and we really do incredible work in all of our courts throughout the state. I am honored to warmly welcome you here today to take part in this incredible ceremony. It's a birthday party. The Fulton County Courthouse is turning 250 years old. Absolutely amazing. Thank Administrative Judge Felix Katina and Fulton Family Court Judge Gerald McAuliffe and his entire team for organizing today's amazing event. Let's give them a round of applause, please. As the Deputy Chief Administrative Judge, a year ago, I came to visit all of the districts, and one of the courts I visited a year ago was this court. And Judge McAuliffe actually told me that he would like to have this celebration back then, and I said, let's get it done. Whatever we need to do to get it done, I think it's important. So it's amazing a year later. Thank you for your entire team. I want to also thank Presiding Justice Elizabeth A. Gary for her extraordinary leadership of the Appellate Division, 3rd Department, the department in which this court sits. Judge Gary. Thrilled to have our new acting Chief Judge of the Court of Appeals, the Honorable Anthony Cannataro. Please, let's give him a round of applause. The esteemed judges of our Court of Appeals here with us this morning. Associate Judge Jenny Rivera, Associate Judge Michael J. Garcia, Rowan D. Wilson, Judge Madeline Singis, Judge Shirley Troutman. Appeals will actually hold a historic general session this morning in the Fulton County Courthouse in honor of this court's 250th year birthday, which is absolutely amazing. Thank you for coming to do that. I want to give a special recognition to the Board of Supervisors, especially Clerk John Stead, who with the County Facilities Department constructed the bench that the Court of Appeals will be sitting at and hearing argument today. The bench was very small for one judge, and they constructed an entire bench. So thank you very much. That's absolutely amazing. Let me also thank our former Chief Judge, Janet D. Fiore, for her remarkable leadership of our courts, and our Chief Administrative Judge, Lawrence Marks, for his dedication and unwavering guidance. Unfortunately, he could not be here, but he sends his warm wishes on the occasion of this 250th birthday. I want to acknowledge Deputy Chief Administrative Judge Tomiko Amaker and Chief of Administration for the Office of Court Administration, Justin Barry, for coming today. Thank you. Thank you. certainly thanks to all of the members of the bar and the bench of Fulton County, Montgomery County, and all of the surrounding counties, all of the elected officials and dignitaries, including Mayor Amy Pratt for coming, all of you for coming, and especially the Johnstown High School for coming to be with us this morning. Thank you all for being here. Now, the Fulton County Courthouse, as you know, was built in 1772, when New York State was still a British colony. That makes this the only colonial courthouse still in operation in New York State. Florida Supreme Court Judge Charles Kennedy once said that the construction of a courthouse is a long-term investment in a building where important business is done. Therefore, courthouses should be dignified, durable, and functional. This Fulton County Courthouse is the gold standard of those lofty aspirations. This courthouse is a pioneer of justice. It was created for doing all legal business west of Albany, which is, think about that, the territory that that includes. And there's a wonderful book by Judge Best that I was given an autographed copy, and that is actually the title. So let's give him a round of applause for that. The court began with a caseload of 6 cases. Now, I'm hoping that there were no standards and goals issues back then with that heavy caseload. Although the name changed a few times over the years, what it stood for and what it stands for today has not changed. Each and every day, courts throughout the great state of New York strive for excellence, strive to administer justice effectively, efficiently, and expeditiously, and provide access to justice for all. And when we reflect on the number of people who have entered the halls of this amazing courthouse over 250 years seeking justice, it is truly humbling and inspiring. Let us take a moment during this remarkable birthday presentation on the semi-quincentennial, that's half of 500 years, of this working courthouse to renew our commitment to strive for excellence, to provide access to justice for everyone, and to continue the important legal business of this court and all courts throughout the state of New York. So happy birthday, Fulton County Courthouse. And at this point, I was going to do a rendition of Marilyn Monroe singing Happy Birthday, Mr. President. But the Chief Judge indicated to me, no, that will not do on this occasion. So I was going to say, enjoy the program, be well, and thank you, but I'm also told I'm the MC. So I will not say that until the end of the presentation. But thank you all for coming, and God bless you, and God bless this court. May the lights in and around this court shine forever. We will continue the program with the presentation of the colors by the New York State Court Officers Ceremonial Unit. Please come forward.
Port arms. Present arms.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We will have the national anthem by Autumn Kurtz and the Johnstown High School students.
Right shoulder arms. Right face. Mark time, march. Forward, march.
Although you didn't hear it, Noel Levy and Samantha Hall Saladino led us in the Pledge of Allegiance. Next, I'd like to call on Reverend Laurie Garamond to bring us the prayer.
It is a privilege to do this prayer and to represent a church that is actually 9 years older than this very courthouse. So how appropriate to have been asked as a representative of St. John's Episcopal Church, which at the time would have been the Church of England when Sir William was here. So I will begin this invocation by quoting ancient words spoken by King David as he recognized God's providence in the lives of the people of Israel, just as they were about to build a magnificent temple to honor God's presence among them. And these are his words. Praise be to you, Lord, the God of our father Israel, from everlasting to everlasting. Yours, Lord, is the greatness and the power and the glory and the majesty and the splendor, for everything in heaven and earth is yours. Yours, Lord, is the kingdom, which it would have been then. You are exalted as head over all. Wealth and honor come from you. You are the ruler of all things. In your hands are strength and power to exalt and give strength to all. Now, our God, we give you thanks and praise your glorious name. And so I continue with a prayer for the courts of justice from the Book of Common Prayer, which is a book written before this courthouse and this town, in fact, was established, but a book carried over by Sir William Johnson when he came here to settle and to work. A book that guided the prayers of the first church he established in our city, St. John's Church, and a book that still guides our prayers just across the block today. It guides our worship and it guides our hearts. I will use traditional language as I pray to remind us of the time in which this courthouse was built, a time in which faith and hard work and grit defined the founding not just of this courthouse, but of this city, virtues which are still sorely needed today. Almighty God, who sittest in the throne judging right, we humbly beseech thee to bless the courts of justice and the magistrates in all this land, and give unto them the spirit of wisdom and understanding, that they may discern the truth and impartially administer the law in the fear of thee alone, through him who shall come to be our judge, thy Son, Jesus Christ. Amen.
Next, I want to turn the program over to your administrative judge, the District Administrative Judge of the 4th Judicial District, the Honorable Felix J. Katina.
Thank you, ladies and gentlemen. Acting Chief Judge Anthony Cannataro, associate members of the Court of Appeals, our presiding Justice Elizabeth Gary of the 3rd Department, our special guests here this morning, students and friends. Thank you all for being here to commemorate the 250th anniversary of the Fulton County Courthouse. It is my honor and privilege to have been asked to speak on this historic occasion and to reflect upon the significance and importance of the courthouse to all of us. The residents of Fulton County, and we as judges, attorneys, and members of the community are justifiably proud of this colonial courthouse, which, as you know, was built in 1772. It is the oldest courthouse in the state of New York and one of the oldest in the country that is still in use. 250 years. 250 years. I just celebrated my 35th wedding anniversary, and I thought that was a long time. At the time when this courthouse was being constructed, where we are standing today was then known as Tryon County. And at the time, Tryon County and Johnstown stood on the fringe of what was then the great western frontier. At the time, Sir William Johnson was the superintendent of Indian Affairs, and Native Americans in the area numbered in the thousands. Looking out these windows in 1772, you would have seen nothing but wilderness. In 1772, neither the state of New York nor the United States had come into being. The land was controlled by the British. This area was originally part of Albany County. However, at that time, the means of transportation and communication was so slow that the seat of the county being in Albany was deemed too remote for local settlements and for proper effectiveness. And so, on March 12, 1772, the Provincial Assembly created Tryon County out of the western half of Albany County and designated Johnstown as the county seat where the King's Court was to be held. At the time, the county included all of the territory west of Albany County to the boundary line settled with the Indians in the Fort Stanwix Treaty of 1768 and southerly to the northern boundaries of Orange and Ulster counties. The name Tryon County came from Sir William Tryon, who was then the colonial governor of New York, whereas Johnstown was named for Sir John Johnson, the eldest son of Sir William Johnson. Construction of the courthouse commenced immediately in 1772 under the direction of Sir William Johnson. The cost of construction, $11,130, and Sir William personally contributed 500 pounds, and probably more importantly, 25 gallons of rum to the laborers during the hot summer months of 1772. The building was only partially finished when almost 6 months later, on September 8, 1772, 250 years ago to the day, Governor Tryon came to dedicate the courthouse, and the first court of general sessions to be held west of Albany was convened. Among those present on that day were 3 judges and 4 assistant judges. Included among them were Guy Johnson and Sir John Johnson, as well as Gels Fonda, an ancestor of actors Henry and Jane Fonda. However, in place of these chandeliers, tallow candles or smoking whale oil lamps were likely used to light the chamber, and writing was done with a quill. Of course, electric lights didn't come in for more than 100 years after that. A grand jury was sworn in that day, and the legal history of the courthouse began with a load of 6 cases, as you briefly heard from Judge St. George. For many years, this was the only brick building and the only courthouse between Albany and the Pacific Ocean. And so we are honored to commemorate that session by having the judges of the Court of Appeals hold court here in what is now known as the Fulton County Courthouse. In the cupola of the courthouse is a wrought iron triangle used to announce the sessions of the court since the earliest days of the court. A hammer on a hinge strikes the triangle when the rope is pulled. This old bell was rung upon learning of General Cornwallis's surrender at Yorktown, upon receiving news of the signing of the Declaration of Independence, the U.S. Constitution, and the 200th anniversary of its signing. And today, in honor of this anniversary, the bell will once again ring to announce the session of the Court of Appeals. Sir William Johnson, Baronet, Superintendent of Indian Affairs for all of British North America, Major General of the British Army, father of Tryon County and founder of Johnstown, was born in 1715 and died July 11, 1774, shortly before the outbreak of the Revolutionary War. Sir William was held in high esteem by the Native Americans of this continent because he never broke his word to them. Sir Johnson saw the conflict coming, and he was torn between loyalty to his king, whom he had tirelessly served, and loyalty to his country, which he so passionately loved. And so in the summer of 1774, he held a fire council with close to 1,000 Iroquois near Johnson Hall to obtain a pledge of neutrality from the entire Iroquois Confederacy in the war which was imminent between the British and the residents of the colony. 2 years later, the Revolutionary War broke out and Johnson's descendants sided with the British. It has been said that no chapter in American history is darker or more replete with greater tales of horror and inhumanity than the Revolutionary Chronicles of Tryon County, and through it all stood this courthouse on the fringe of the western frontier to bear witness to the birth of a new country. It is a notable fact that it was in Tryon County at the siege of Fort Stanwix that the stars and stripes of the American flag were first unfurled as a garrison flag after the design was adopted by a resolution of Congress on June 14, 1777. It was in Tryon County that the first shot was fired in the Revolution west of the Hudson River. It was also in Tryon County, within the present limits of the city of Johnstown, right where we are Johnstown, right where you are right now, that the last and one of the bloodiest battles of the Revolution was fought in October 1781. Peace had been declared 5 days earlier when General Cornwallis had surrendered at Yorktown, but of course, news and information traveled slowly in those days. During the war, Governor Tryon sided with the British and plotted the murder of General Washington by turning one of Washington's personal lifeguards against him and having him place a fatal dose of poison in a dish of peas, which was to be served to the general. But Washington's faithful housekeeper became aware of the plot and warned Washington in advance. The lifeguard was arrested, found guilty, and hanged in what was the first military execution in the Continental Army. The plot was directly attributed to Tryon, and as a result, in 1784, in deference to public sentiment, the legislature changed the name of Tryon County to Montgomery County in honor of General Richard Montgomery, a brilliant young hero of the Revolution. With opening of the Erie Canal in 1825 and the Utica and Schenectady Railroad in 1836, travel and transportation were diverted south, and ultimately Johnstown was abandoned as the county seat in favor of Fonda in 1836, and the courthouse and clerk's office were sold at auction for $1,650. This caused a great deal of resentment, and again, in deference to public opinion, the northerly section of Montgomery County was broken off and renamed as Fulton County in 1838 in honor of Robert Fulton, inventor of the steamship. the courthouse was repurchased and Johnstown once again became the county seat. Over the years, this courthouse was a scene of many important trials, and many prominent attorneys practiced law in this courtroom, including Daniel Cady, Alexander Hamilton, and Aaron Burr. Judge Daniel Cady was not only a member of the New York State Assembly, but he was elected to the U.S. Congress and was the first justice of the Supreme Court from Fulton County, serving from 1847 to 1855. His portrait, which you see up above the students, on the wall, has hung since he presided. Judge Cady was famous in one other regard as the father of Elizabeth Cady Stanton. At a time when education for young women and girls was not common, Elizabeth benefited from the study of law books and discussions about the law with her father and students of the law who also studied with her father. From her frequent visits to the courthouse and her father's office, she noted the disparate treatment of women and became a champion for women's equality under the law. Together with Susan B. Anthony from nearby Canajoharie, they led a lifelong battle for the political rights not only of women, but for African Americans and the abolition of slavery. Following Judge Cady's retirement from the bench in 1855, Fulton County did not have a resident JSC until 1901 with the election of Edgar Spencer, who served until 1915. Thereafter followed Judge Willard Best from 1946 to 1970, Judge Arthur Alisi from 1968 to 1977, Judge Carol Walsh from 78 to 1990, Judge Robert Best, who you heard from 1987 to 2006, and finally Judge Richard Alisi, the son of Arthur Alisi, from 2006 to 2019. In 1972, on the occasion of its 200th anniversary, the Fulton County Courthouse was designated as a National Historic Structure and also designated as a historic structure by the state of New York. However, in the 1980s, plans were floated to move the Supreme Court out of this historic building and into the third floor of a new jail facility that was to be built, or into the chambers of the Board of Supervisors. However, one man stood up and objected to those plans, and for years championed for the restoration and continued use of this building as a courthouse. He served as president of the Fulton County Bar Association during the celebration of the courthouse's 200th anniversary in 1972. In 2003, he was honored by the Fulton County Bar Association for his efforts in preserving and restoring the Fulton County Courthouse. And nearly 20 years later, this year, at the age of 93, he published a book on the history of the Fulton County Courthouse entitled Everything West of Albany in 1772. He has generously donated multiple copies to the Fulton County Bar Association. And ladies and gentlemen, we are so fortunate to have him with us today as our distinguished guest. Please join me in welcoming and acknowledging the lifelong efforts and accomplishments of none other than our own retired Fulton County Supreme Court Justice Robert Best, as I call on him at this time to say a few words. Judge Best.
I think Felix read my book. Although I don't know for sure. It's in a lot of different books. It's a history. I don't want to add much to what was said, but I do want to say that the governor came and gave a speech when the courthouse was 100 years old. When it was 200 years old, I was around, and we tried to get the United States Postal Service to make a stamp to commemorate the courthouse. Well, we got a history lesson. We weren't the oldest courthouse in the country. It was still in existence. There's 3 in Virginia,
and one in North Carolina that are still operating, they say. I visited them, and not one gets the use that we do of this courtroom today, but they're there. And one of them, two of them are very handsome buildings. A couple are not. But they're still there, so and they claim, and they were courthouses, and they still have a designation as a working courthouse. But we got the history lesson. We didn't get the stamp, but we had a birthday party anyway. So I was in court for quite a while, and in the 80s, they had an assessment of this building by an architectural firm as to whether or not it was in good shape to be a courthouse. And they came back with a good report. It needed a lot of things, but it was in good shape structurally, and they recommended that we keep it as a courthouse. So that was done by the county. Well, then, later, they started talking about building another courthouse. And somewhere outside of town, I guess. But they wanted to they needed a jail. So they wanted to build a jail and a courthouse with the jail underneath and the courthouse up top. And that didn't seem to set right with anybody. So they abandoned that and started thinking of other things to do. And they finally decided to change this courthouse and use the supervisor chambers up there for a courtroom. And I don't think the supervisors like that either, but they have a nice room up there. But anyway, the Bar Association didn't think that we should give up on the courthouse. So one year, Judge Kay was Chief Judge of the Court of Appeals, and she wrote in her annual report that some of the courtrooms or court systems were not up to stuff and should be appraised and fixed. So a couple of years later, this planning started about another courthouse, and it was not being accepted by a lot of people, I guess. So anyway, I wrote to her. There were petitions around. Mr. Ford, who was the court officer then, had been a court officer for a long time. He kind of got affixed to the courtroom too, the courthouse. And he started circulating a petition to keep the courthouse as a courthouse. And finally, the supervisors, I guess, decided that that may be the thing to do. But in the meantime, when Judge Kay wrote the letters wondering who was doing stuff for their courtrooms, the courthouses, she said, some of the counties are dragging their feet. They're not doing much about it. So I wrote to her, and I said to her, we have an old courthouse here that needs to be preserved as it was at that time on the National Register and the State Register. So anyway, they decided she decided that there was merit to that argument. And she had advised that we go to the committee that she has to determine the suitability of courtrooms and courthouses and make our case. So Dick Alisi was up here, and I went down to that committee and made our argument and said we think we ought to keep the courthouse we have and fix it and bring it up to date. It did need air conditioning, it did need other things. And that's what happened. The committee agreed with Judge Kaye, and Judge Kaye agreed that we should continue the courthouse. And I congratulate Judge Kaye and think she made the right decision. So it remains. I'm surprised that I remain. But I do. So I thank you, and I thank the Court of Appeals, because they're the ones that made the decision. Thank you very much.
Judge Best, on behalf of the entire court system of the state of New York, thank you so much for your efforts over the years. Ladies and gentlemen, it is now my distinct honor and privilege to introduce to you for some closing remarks the presiding justice of the Third Department, Beth Gary, our presiding justice, the delightful, bright, and shining star, Judge Gary. Judge Gary.
Thank you all for the warm welcome. It is such a joy to be here with you this morning. Thank you, Judge Katina, for your thoughtful and insightful remarks regarding the history and significance of this courtroom on this date. And thank you, let's see, is that good? Tell me in the back if it's not. Thank you, Norman St. George, Judge St. George, for your kind introductory remarks. And thank you for the students, and particularly for the rendition of the Star-Spangled Banner. Thank you. And the Reverend, a great start. This day is really all the more memorable because we are joined by the Court of Appeals, and they're going to continue to mark this commemoration, as you know, by hearing a case or two this morning for the first time in this court's history, I understand. So I would be, I want to move on to some remarks, but I'd be remiss to not also recognize some of the members of my court. My court is the intermediate court. So the cases, my court hears the cases from about the eastern half of upstate New York and 28 counties, including this, as you know. And then some of those might make their way forward to our highest court, who you're going to get to hear this morning. So we're the middle layer. And thank you. Before I go on, I want to introduce some of my members, but thank you to the local judges. You know, pulling this forward was really a remarkable effort, and I got to see that over the course of several months of hard work to make this all happen. But what a great celebration. And I am Judge Best. I am so happy. Thank you to the Bar Association. Thank you, Judge Best, for your singular efforts to make it possible for us to be here today. So, I am joined today by two judges who I think will be well known to most of you, retired Judge Honorable Bud Malone and the Honorable Christine Clark, who sits on our court. The clerk of our court, Bob Mayberger, is here. Deputy Clerk Beth Lifshin Clark. Chief of Staff Andrea Bentley. Most of the members of my court are going to be sitting in hearing cases in Albany this afternoon, so they couldn't all join us here this morning. Celebrations like this one that I'm so glad to join you for are important because they provide an opportunity for us to pause and to look back with gratitude for the solid foundations that we have inherited. And also, I think it's important to note that we need to take a clear-eyed view of how our shared history continues to impact us today. Gathering so that we can learn together and reflect inspires us to carry our best traditions forward into the future, while making progress toward a more inclusive, expansive, just, and prosperous future for all of us. I'm honored to share a letter from our immediate past Chief Judge, the Honorable Janet DeFiore, who was instrumental in making this celebration a reality. The Chief Judge of the Court of Appeals, on the occasion of the 250th anniversary of the Fulton County Courthouse. On behalf of the New York Court of Appeals, please accept our warmest congratulations on the 250th anniversary of the Fulton County Courthouse, the oldest existing courthouse in our state and one of the oldest functioning courthouses in the nation. When Judge McAuliffe invited the Court of Appeals to hold oral argument in the Fulton County Courthouse to mark this milestone anniversary, I proudly accepted on behalf of my colleagues, knowing that it would be a momentous occasion, not only for the New York Unified Court System, but for all New Yorkers. Indeed, we are humbled by the extraordinary history of this courthouse, which has been the professional home of many distinguished members of the bench and bar, including Daniel Cady, attorney, legislator, Justice of the New York Supreme Court, and ex officio judge of the Court of Appeals, whose career intersected with legendary legal figures such as Aaron Burr and Abraham Lincoln. Daniel Cady is perhaps best known as the father of Elizabeth Cady Stanton, the pioneering leader of the women's rights movement, whose frequent visits to this very courthouse inspired her to devote her professional life to the pursuit of equal justice for women. During Cady Stanton's formative years here in Johnstown, the foundation was laid for her later work with Susan B. Anthony, invoking the transformative power of the law to gain for women the right to vote and equal treatment under the law. The judges and professional staff of the Court of Appeals are honored and privileged to join the Johnstown and Fulton County communities in commemorating the 250th anniversary of the Fulton County Courthouse, a treasured landmark that predates the American Revolution and stands today as an enduring beacon of our nation's founding promise of equal justice under the law. Thank you to former Chief Judge Janet DeFiore for these kind words. On a personal note, since I was brought into the planning of this event, I've had such a wonderful time getting to learn so much more about this region's history. I wanted to say a little introductory note. I grew up, because most of you don't know me, I grew up about an hour south of here on a family dairy in the town of Bern, which is part of Albany County. And I spent my legal career about 2 hours southwest of here in Shenango County. So I've had some opportunity to travel and get to know the region and some of the history and the exciting stuff that has happened here. But I'm going to admit, kind of surprisingly and shockingly, I didn't know much at all about Sir William Johnson. And this program inspired me to learn that history and learn about his fascinating life, his contributions to this community, including, of course, this very courthouse, and his tremendous impact on the course of American development and history. So it set me on a journey of discovery this summer, and this was a lot of fun. I visited Fort Stanwix, and I learned even more there about the events, and I highly commend anyone who hasn't been to that national treasure. It was a really great experience. I was more familiar with Elizabeth Cady Stanton and her leadership and activism. I knew of her in part because she also has a connection to Peterborough in Madison County, where her cousin, the famed abolitionist Gerrit Smith, lived, and she would summer there. And in recent years, I've learned more about how Ms. Cady Stanton and her contemporaries were affected by the Haudenosaunee women and the role that they played in governance and public life. But before I undertook the preparation for this event, I was less familiar, and admittedly, with her family's very prominent position here in Johnstown, and I didn't know the extent to which her early views were shaped in this courthouse, where her father sat as a judge. So, these historical celebrations are important because there's always so much more to learn, and the opportunities are there for us to broaden our understanding of the world and how it works. We can learn from stories of fortitude, ingenuity, collaboration from our past, as well as the stories of exploitation, violence, and there was a lot of it, and frankly, brutality. And may these stories that we can learn and share together inspire us to press on in our own endeavors when we find ourselves in difficult or challenging, turbulent times. To the extent that we may disapprove of any actions or attitudes of our forebears, we are reminded of our own place in history and to do better ourselves right here, right now. We have not yet met the full promise of equality, justice, and freedom for all. But the path is there before us. And that path is built on our knowledge of our past. History is worth studying and knowing and acknowledging and celebrating because it can inform our judgment in the most powerful, the most exciting, the most important way. Who we are, who we might be as a nation, bringing our best traditions into the future is something that we as members of the legal community, we as members of the broader community are charged with doing here and now. And that is the power of history. So that's my my exhortation. I am again so glad to be here with you all. I look forward to hearing the arguments of my esteemed colleagues, and I am again, I think I said it, but I'm really excited, Judge Best, to meet you in person and to have this treasure. And I will be delivering to Judge McAuliffe a copy of the letter from our former chief. Thank you all very much.
Thank you. Judge Gary, thank you very much for those remarks. And ladies and gentlemen, that concludes this part of the program. I understand Judge McAuliffe will take a short break before we move to the next event in the program, and that is the exciting session of this Court of Appeals. So we'll take a short break. Thank you so much for coming thus far, ladies and gentlemen. Thank you.
back to the other one. Is that what's in here? I think it's got to go back that way. Can you zoom out? Jacob. How's that look? I would say out. I'm out. Zoom out. I'd say a little more. A little more. Zoom out. Go one more. One more. I think that's good. Yeah. What do you think?
Excuse me, if we could have a seat for a minute, if we could all have a seat, the Court of Appeals is almost ready to take the bench. You all take your seat.
Can everybody please take their seats?
Can everybody please take their seats?
State of New York may now draw near, give their attendance, and they will be heard. Please be seated. Good morning. I have mercifully no prepared remarks before today's arguments, but I've listened to so many proud court leaders and administrators thank their staff for making this event possible, and I just would like to thank our own Court of Appeals staff, led by our clerk, Lisa LaCours, and her staff, for making it possible for us to be here today. I am personally humbled and excited by the fact that the first proceedings in this court took place 250 years ago today, on September 8th, 1772. And I think I speak on behalf of all my colleagues when I say we are very, very excited to be here. So, let us begin with today's case, which is number 73, matter of Independent Insurance Agents and Brokers of New York versus the New York State Department of Financial Services. Counsel.
Good morning, Your Honors, and may it please the Court. Sarah Rosenbluth for Appellant, Department of Financial Services. I'd like to reserve 2 minutes for rebuttal.
You have 2 minutes.
Thank you. The best interest standard, which has now been adopted in at least 28 other states, is a common sense regulation that uses clear and commonly understood terms to regulate insurance agents and brokers. It is a rational exercise.
Counsel. Good morning.
Good morning.
What is the evil or the concern that the regulation is intended to address, and how does the language match that goal?
Yes, Your Honor. The legislature has made the judgment, as evidenced in a number of statutes, that it is the policy of the legislature in the state of New York that the department shall supervise the individuals engaged in the business of providing financial services and products, and shall ensure a high level of honesty, transparency, and competence when consumers seek out the assistance of these financial business people. And so in terms of the language, what I would like to point to and primarily is page 306 of the appendix, and that contains the regulatory impact statement where the department sets out its authority, and it explains that when it instructs producers to act in the consumer's interest rather than their own financial interests, the department says that goes to the heart of what it means to operate in an honest and trustworthy manner.
Counsel, it seems as if the industry has its own set of fairly similar standards to which they hold themselves. Could we not just rely on their own self-regulation to do the job in the manner in which it appears both of you want them to do it?
No, Your Honor. First of all, this is amply within the statutory authority, and the department also considered comments during the notice and comment period by the industry to the effect of, there are existing standards that are similar, can't we just rely on those? And there are important differences between this rule and other existing sort of rules of self-regulation and also federal rules. Other rules, for example, might require producers to put consumers' interests ahead of their own, but does not prohibit them from considering their own interests. So this goes meaningfully further than existing regulations.
That gets to the matter at hand.
Sure.
Which is vagueness.
Mm-hmm.
Are there differences between your regulation and the ones that the industry imposes on itself that somehow, in the view of at least one lower court, rendered it vague?
No, Your Honor. So there are certain differences in terms of the meaning, the definition of recommendation, for example, and I'll refer here to the model rule. That's not the industry's self-regulation. I'm not exactly familiar with the terms of any self-regulations, but for example, the model rule.
Their ethics standards. I think they have a certain ethical code that they subscribe to.
Sure. I'm not exactly familiar with what those terms would be, but in any event, the terms of this regulation have been adopted in substance and in some cases verbatim by the National Association of Insurance Commissioners, which sets forth national standards, and that has been adopted now by at least 28 other states. So I think that really widespread adoption by more than half the states in the country shows that the terms at issue here are not hopelessly unintelligible. Certainly other.
Is our review here for rational basis
On
on the constitutional question?
the constitutional question, I think that's one way of looking at it, Your Honor. I mean, certainly the agency has authority to, when it is delegating within its sphere of, when it's regulating within its sphere of delegated authority, it does enjoy a presumption that it's acting rationally. And certainly that's not just a matter of presumption here, but it's borne out by the record.
And so if the regulations exactly duplicated the industry code, what about that would make it unconstitutional?
Nothing, Your Honor.
And if it differed?
I mean, it's permitted to differ. The agency exists to regulate as a regulator that represents different constituencies than does any self-regulating entity of the industry. So it's absolutely permissible for it to differ meaningfully and, in put different emphases than does any self-regulation.
Counsel, when we look at the vagueness test and we look at notice, the notice prong, person of ordinary intelligence generally expressed, is that different here? Are we looking at a different audience? Are we considering this regulation through the lens of a very highly regulated industry?
Yes, we are, Your Honor, and that is set forth, that standard is set forth, for example, in the Hoffman Estates United States Supreme Court case, where it talks about the difference in vagueness standards that would apply, for example, in criminal statutes, where any ordinary person is regulated and also faces deprivation of liberty by contravening that statute, on the one hand, and on the other hand, economic regulation that does regulate, as you say, highly sophisticated and highly regulated entities. And it's worth noting here that insurance is one of the most heavily regulated industries nationwide, and certainly in
So
the
are you
state too.
suggesting that the vagueness standards that we apply in criminal cases, when you're considering insurance, should be no less, because one involves liberty, the other the contrary?
The vagueness standard in this case that applies to economic regulations is less strict than that applies in the criminal context. Regardless, I think we satisfy either test. But one reason why, in addition to the sophistication of the parties at issue, another reason why we apply a less strict test to regulated, business entities is because there is that opportunity for clarification. And the terms here are clear, even without
Okay,
resort
so
to any.
now let's get to that one.
Sure.
Which is where I was hoping we'd get. So reasonableness, I think you have a very good argument on that. I'll ask your adversary about that. But suitability, how is that not vague? That seems such a broad concept. So many factors go into that are idiosyncratic for any particular client or customer.
Right, so well, first, the term suitable is itself separately defined in section 224.3H, and then there is, in subsection G, there are those factors that are the quote-unquote suitability factors. Now, the fact that they may call
Well,
for
how
the.
is suitable defined?
Suitable is defined as in furtherance of the consumer's needs and objectives based on the information provided by the consumer. And the suitability information admittedly calls in some instances for subjective information from the consumer. Some's pretty objective, some's age, income, marital status, and the like. But there are some admittedly more subjective factors that the consumer can choose to answer in a variety of ways. For example, financial needs, objective, risk tolerance. But the fact that that the regulation calls for the solicitation of subjective information doesn't.
It is possible with that particular term, though, even with the factors and other, let me call it guidance for a moment, that you're providing for let's just say the agent for the moment. The agent thinks it's suitable that the individual themselves would never think is suitable. How do you resolve that issue? Do they always have to defer to the customer, the purchaser's
Well,
idea of what is suitable, which may not, obviously, because you're going to an expert, which may not be a result of a full analysis of all the relevant concerns?
Well, the definition of suitable is tied to the consumer's own financial needs and objectives. So assuming that there has been no miscommunication, the consumer and the producer should be agreeing on what is suitable. And just further to your point about the potential.
I'm sorry to give it, does that mean that they have to agree on what are the concerns and factors that go into that calculation to make the determination as to what is suitable?
I mean, certainly the producer is exercising some expert judgment, but it is all based on what the consumer, on the information that the consumer provides. And importantly here, there is no requirement, as petitioners suggest, for the producer to somehow displace individual autonomy, to override consumer stated preferences.
So what you're saying, as long as they have the relevant information provided by the producer, the ultimate decision can be made by the consumer, but they are still fulfilling their responsibilities?
That's exactly right, Your Honor. And that is underlined in Section 224.4F, which says that a producer has no obligation and will not be exposed to any liability if the consumer decides to go against his transaction, if the consumer rejects the transaction.
The list of suitability information, is it exhaustive or is it exemplary?
It's exemplary, Your Honor.
So there could be other types of suitability information not listed. How's the producer supposed to know what that is?
Well, presumably in such a case, a consumer will, in the course of an open-ended conversation, might refer to any pieces of information that might be highly idiosyncratic to that person, and therefore would not be captured in the exemplary list, but, that consumer might inform the producer that this one thing happens to be really important to me. So there's no need to sort of be clairvoyant in.
But what if the client doesn't tell you something, but DFS thinks, well, anyone with this kind of expertise who's working in the best interests of the client would have asked about those things? Who's liable in that scenario?
Well, if the producer solicits, certainly if the producer solicits all the examples of suitability information, there would be no requirement to somehow make up additional factors to solicit. There might be a scenario where a consumer suggests so that something's important.
Then you're saying the floors set out are the factors,
Are the
floor.
Yes.
And you're not expecting them to exceed that. If they
They
do
need-
under
they
the
need
scenario,
not.
that's fine.
That's
But if
right.
they don't, they've complied with the responsibilities as DFS sees it?
Yes, in most cases, yes. I could potentially construct a hypothetical in which a consumer suggests that there's one idiosyncratic piece of information that's extremely important to that person, and the producer probably would want to understand that and base a recommendation on that. But I can't, off the top of my head, consider
But
what
it
that.
sounds as if you're saying essentially that if the producer goes through the checklist of the suitability information items that are in the regulation, that's a safe harbor.
Yes, and that's almost right, Your Honor. Certainly going through the checklist of suitability factors is an important step. There are a few other steps that are listed out in Section 224.4B, but yes, that's exactly right. And again, one of the most important points I would like to make this morning is that the best interest standard calls for adherence to a process. It does not call for any particular substantive outcome.
Counselor, you note in your briefs that insurers can get additional information if they can call in and ask for help with guidance with the regulations. First, how do you think that helps us in a vagueness analysis? And second, couldn't it be that if so much support is needed, that in fact the regulations might be too vague?
Sure. So with respect to your first question, sort of doctrinally where that fits in, I think, is, as again, I referred to the Hoffman Estates case, where it says that, the reality of a highly regulated industry is that there is that opportunity for clarification, a give and take, perhaps a resort to administrative process, and here we detail in our brief sort of how that information is communicated. So that really alleviates the concern that anyone's going to be, for example, subject to substantial fines or penalties. It really alleviates the notice problem. They have really a full opportunity to clarify, and more than just resort to the agency. Another critical point here is that they're under supervision by insurers. All of these producers, they're not islands here. They're working with insurers, and there are very important duties of supervision that are again set out in 224.6. And so the insurers and already have been really a huge resource here for producers in prescribing forms, really making it clear to producers how they expect this to go. And there's training and the like. So that training again also is another opportunity for clarification. To the extent that clarification is needed, I certainly don't think that weighs against or that weighs in favor of vagueness here. I think that's
Ms. Rosenbluth.
okay.
May it please the court, Howard Kronberg from Kydell, Weldon, and Cunningham for petitioner respondents. Your Honor, I'd like to preface this by saying this is my first time arguing before this court. I'm honored to be here today. I would have been a little nervous anyway with all of this, so if I constantly get dry mouth and need water, please don't let it indicate.
Those are the people you need to be worried about.
Okay. It's not an indication of any non-belief in my position. I remember from law school being taught that when there's a complicated issue, go to your best argument. And it's two and they're interrelated. The first is, it is unconstitutionally vague. And the second is, it reverses your decision in Murphy v. Kuhn. It completely changes the common law standard to be applied here. Preface this by saying, my first job in law school, my first year in 1981, was as a law clerk at Wegenmeyer's, working with Dennis D'Antonio, who I understand yesterday argued an insurance case before you. I've been doing it ever since. In 1987, I started to do E&O defense and have been doing it throughout. We are the successor, our law firm, to Lustig & Brown, which argued Murphy and Hoffman and Chase Scientific. We've been counsel for the Big I, IABNY, for many years. We're the attorneys, my partner Jim and I, that literally get the call every day, in the morning, throughout the day, by insurance brokers with this question: what do I do? Insurance agents and brokers in the state of New York want to do what's right by their clients. They want to do what's right, of course, by the DFS.
And counsel, what
Yes.
terms specifically in this regulation are they having trouble with?
All of it, Judge.
But tell me some terms. We can say all of it, and there's some broad language in the appellate division, but could you identify for me the terms that you're getting calls on or you think specifically are vague?
Okay. Suitability in the regulation is a tautology. You cannot define suitability and then say suitability is defined as what is suitable and documents that are suitable. One of the judges asked about the checklist of suitability documents. That's incorrect. It's not a checklist. DFS is wrong. It's examples, and therein lies the problem. One of my great problems with this regulation is this. Murphy said, procure the coverage requested. It's a bright line. To remember this, and this is going to sound crazy, I had the word sausage written in my papers. Why? Because as we all remember growing up, nobody wants to know how sausage is made. We don't care. If it's delicious, that's fine. Sausage is, making of it is outcome determinative. Murphy is outcome determinative. The process doesn't matter. It doesn't matter how a broker or agent gets the insurance as long as it's what they wanted.
But counsel, it seems as if the current thinking is these products are so complicated now that what's requested is very often the result of a recommendation made by a person who's in a position, at least from the perspective of the consumer, to know what it is, the product is, and how it works. And that's going to greatly affect the consumer's decision about which product to select. And this regulation, to me, distilled to its simplest form, is just a command that you think about your client before you think about yourself. What's wrong with that?
Nothing, Judge. I don't think this does that, though. And
But again, Judge Garcia asks you specifically
Right.
about the questions that you were called upon to answer from clients. So what is the question that is most asked that is a problem with this reg?
no, my apologies if I wasn't clear. We're called on to answer questions all the time about regulations. We have not gotten anything on this yet, okay?
But so the suitability information definition has existed for something like 15 years? And you're the go-to people and nobody has asked you what that means?
No, they haven't,
So
Judge.
maybe they understand it.
Correct. I don't think so.
What I heard Ms. Rosenbluth say, and maybe you don't agree.
Right.
Was that at least as to the suitability information.
Yes.
If a producer goes through that as a checklist and asks the client about those sorts of information, that would be a safe harbor with a couple of caveats. One caveat is that there's no obligation on the producer, but if the potential customer says, well, wait a minute, there's some other things about my situation you ought to know, the producer's got to take that into account, although there's no obligation to ask for that. And there are other pieces of regulation outside of the suitability information that the producer's going to have to comply with as well. But essentially, that checklist is, she said exemplary, but if you complete it, that's a safe harbor. Would that be vague? If that's the interpretation?
If that language is specific in the regulation, which I don't read it that way, maybe that would be different. But I don't.
The maybe is what's, let's see if we can get past the maybe. Suppose that was the definitive interpretation. This is a safe harbor if you go through that checklist. Would you still have a vagueness problem?
On that particular part, no.
Okay.
I don't think I would.
So then what are the other parts that you would have a vagueness problem with?
Whose interest is at stake? Because as we litigated in the Vestal case, which you refused to hear from the Third Department, I represented a life insurance broker who was asked by an attorney husband to get life insurance that he was absolutely not qualified for because he had drug and alcohol problems.
Yeah, but isn't there a definition? The consumer means the owner or prospective purchaser.
sorry, Your Honor?
What's vague there? There is a definition. Consumer means the owner or prospective purchaser.
But that's
What is vague in that?
because the best interest, the way the regulation defines it, and is admitted in the reply brief.
No, I'm asking you about that definition. What's vague in that? Consumer means the owner or prospective purchaser.
Because
Of the policy, excuse me.
Because it's an incomplete sentence.
Okay.
It's the consumer, it has to look, and the agent has to look at the best interest for the consumer. But they admit in the reply brief, and I'm happy to cite the exact page, that it could also mean the beneficiary of a life insurance policy. So
No,
it's,
it doesn't say that. But I'm happy to see what page you're talking about. I think they've clarified that it's this definition that applies, but if I've misread their brief, that's fine.
At page 4 of their reply brief,
Okay.
the needs of the beneficiary should be considered, first paragraph, last sentence. Now, they go on to say, yes, it's the
Okay,
consumer.
but how is considering, that sounds like a consideration, not that that's the consumer.
Fine, because to go back to the Vestal case, the life insurance policy that the applicant wanted was completely unsuitable, one for himself and for the needs of the beneficiary, okay? The Third Department upheld dismissal for us based on Murphy, saying, you asked for this, you got it, and that's fine. Murphy will no longer be good law. This regulation reverses it. And to me, it's absolutely clear. And if I may,
Let's say we disagree with you. Let's say we're not so clear. Do you lose?
I'm sorry, Your Honor?
Let's say we disagree with you about this, your argument that this overrules Murphy. Let's say we do not see it that way. Do you
Okay.
lose?
Yes.
Since you've already said the factors, you agree with Judge Wilson, the factors
Yes.
of safe harbor, you said, okay, with respect to that, maybe that resolves it. What else remains? The consumer is defined, what else?
You mean, what other parts
Yes,
are
what else
vague?
makes it vague? I'm trying to get to Judge Garcia's question. What are the actual parts of it are vague?
The vagueness comes from the fact that this is, as mentioned and is clear, it's a process. You're going to have the DFS investigate agents and brokers about a process. And if I may, I think there's actually something dispositive of my argument, which both I cite at page 23 of our respondent's brief, and DFS cites at page 4 of their brief, which is an official DFS, there's a hyperlink there. And it's a 16-page document that clarifies the regulation. Now, from my perspective, just as a layperson, I would say, if the regulation is clear, not unconstitutionally vague, why do you need a 16-page explanation of what you were trying to say? If, as they say in their papers, they're the experts and they've been doing this and they took all this time to draft this regulation, why do you need 16 pages to clarify it?
I suspect that some of your insurance policies are longer than 16 pages in pretty small type.
Very much so, Judge. And the law in the state of New York is that an insured is bound by that policy, whether or not they can even speak English or whether or not they have read it. But that's not going to apply here. I think it's really telling that at the very first question, again, it supports my view that this overturns Murphy, and it says that, quote, the department views the best interest standard more as a process than as a singular outcome. Murphy is an outcome case. This regulation
But
by its...
isn't that simply recognizing the obvious, that a consumer has particular concerns? Perhaps some are shared by other consumers, but they may have a unique situation. And as Judge Canataro has already said, what is the regulation requiring but that the person who's trying to provide these expert services to the consumer is not thinking about how deep they can make their wallet, but what are the needs of the consumer? That's your priority. Yes, of course, you're going to make a living off of it, but the priority is the consumer, not you.
Your point is well taken, Judge, and I'll go back to what you said in 1997 in Murphy, which is insurance brokers and agents are not financial managers, and that insureds are the best ones to know what their needs are. And I think that was true
That's why
then.
it's about the recommendations that you make. The consumer can make their own decision whether or not they're persuaded and think, yes, that makes the best sense for me. Thank you for the information.
I think you're correct, Judge, and I think you can drive a truck through what a recommendation is or isn't. As somebody who handles the litigation when everything falls apart, I will tell you, every plaintiff's attorney, like Mr. D'Antonio, who argued yesterday, who handles these cases on behalf of plaintiffs, they're going to argue that any statement was a recommendation. What's going to happen is the courts are going to be inundated with cases trying to clarify what these terms mean.
Counselor, suppose we determine that it's not unconstitutionally
Yes.
vague. What are you asking for? Remittal for the remainder of your issues or for us to decide?
I'd like you to decide, but I'm glad you mentioned that, Judge, because this is how I'd like to conclude. As I said, I think if you let this regulation stand, there's going to be more litigation than anyone can imagine, and it's going to go against the admonition in Murphy that warned against opening up the floodgates to more litigation. The worst that can happen is if you affirm it, is we'll go back to the drawing board. I mean, it won't be the end of it. The DFS and my clients are going to sit down together, I would like with our involvement, and figure out something that's workable. I don't believe it's the end of the line. Thank you for your time.
Thank you, Counselor.
I'd like
Counsel, can you address this issue about the reply brief, page 4?
Oh, sure. That's about the consideration of the interest of the beneficiary. Sure. So as Your Honor identified, the regulation does define consumer as the owner or prospective purchaser of the policy. The guidance makes clear that the needs of the beneficiary should be considered to the extent that they're relevant to serving the purchaser's interests. To the extent that they diverge in some ways or that the purchaser does not have a certain sense of what the beneficiary's interests are, the needs of the purchaser control.
What do you say with respect to the claim that there will be much litigation on the issue of recommendation?
So my first point, Your Honor, is that this regulation has been in effect in some form or another, including with a similar definition of recommendation since 2010, so for over a decade. There are 0 reported cases of consumers bringing lawsuits to enforce Reg 187. So I think that should give this court comfort that we're not opening the floodgates
Well,
here.
but what's different? Obviously, something's different.
Sure, there are differences, and obviously it is a more consumer-friendly standard. However, there are a number of safeguards built into the regulation that mitigate against this risk of inundation, as it were. For example, the regulation makes very clear in a number of places that neither the department nor consumers are to second-guess producers' judgments made with the benefit of hindsight. The definition of best interest ties the duty to the circumstances then prevailing at the time of the recommendation. Similarly, the definition of suitability information ties...
Are you making the producer fiduciary?
Absolutely not, Your Honor. The fiduciary duty is an ongoing duty that basically requires a fiduciary to act in the interest of another on an ongoing basis, and usually exercises discretionary control over managing the beneficiary's assets or making decisions on behalf of the beneficiary.
Counsel, what about this argument that really, even though the regulation focuses itself towards a recommendation, the whole interaction between the producer and the prospective client is the process of making a recommendation. So basically, everything that takes place in the context of that relationship could conceivably fall under the umbrella of recommendation.
Right. Well, the definition of a recommendation is tied to something that reasonably is interpreted as advice and results in the consumer entering into a transaction in reliance on that advice. So there's going to be a limited subset of statements made within that interaction that actually are reliance-inducing. And then just to briefly respond to my opponent's invocation of the Vestal case, again, as this sort of harbinger of bad things to come. That case would not have come out differently under this rule. In that case, the husband made material misrepresentations on his policy, on his application. Under 224.4F, the producer is not liable if it is later discovered that a recommendation was made on the basis of materially inaccurate information provided by the consumer.
Counsel, on I think Judge Singas's point, if we were to decide your way on the vagueness question, what do you think about the rest of the issues? Back to the appellate division or for this court?
No, I agree with Mr. Kronberg here that these are pure questions of law, and the court should proceed to dispose with the entire appeal and all the issues presented.
Thank you, counsel.
Thank you.
All please rise. Hearing, hearing, hearing. All persons having any further business before this Court of Appeals held in and for the state of New York